certified class.
And welcome back to the Prima.Law podcast. I'm your host, attorney James Betzold, and here we are again. Again, it's like those who promised and implemented Project 2025 are really sticking to their word. They're really sticking to the playbook. In fact, if you look on the USCIS website, you'll see that the logo for Project 2025 is shown prominently on the main page. Okay, in a form of the 2025 year in review for USCIS. So we're going to talk about that. And we're also going to talk about what's happening with naturalization cases for certain countries. There's a list of countries now where they've said we're not going to even approve naturalization now. We're just pausing it. But we see travel bans. We see all these other things coming back that we dealt with in the first Trump administration. So we're going to talk a little bit about that. And surprise, surprise, we're going to talk about the H-2A visa, and I'll tell you why. I think that may be the Underdog visa for next year. I mean, I know that there's a lot of attorneys who really got excited about U visas and T visas, and I think we may see that come to a close, and we might see H-2A visas be something that can take their place. Stick with us. We're going to go over all of it. Let's start the show. Okay, so following the shooting of two National Guardsmen in Washington, D.C. by an Afghan national, the administration has officially paused all immigration applications, and they're saying it's for green cards and citizenship for nationals from these 19 high-risk countries. Let's go over some of these countries. I have the list. I pulled it up right here. You have from Africa, you've got Chad, Eritrea, Libya, Somalia, Sudan, Republic of the Congo, Equatorial Guinea. From the Middle East, Iran, Yemen, Afghanistan, Burma. And from the Americas, Haiti. And then there's 7 more countries: Cuba, Venezuela, Sierra Leone, Burundi, Togo, Laos, Turkmenistan. And as of January 1st, 2026, the ban is going to include Mali, Niger, Burkina Faso, South Sudan, and Syria. So the processing freeze is hitting these 19 countries. So it's not just green cards, which you might expect. You might say, okay, well, they got to do extra security clearances. We want to make sure these people are safe. But they also stopped processing of naturalization applications, and that is problematic for them. It's problematic for them because there's actually a statute that says how long a citizenship application can be pending before there must be a decision on it. And as we know, there are a couple people who are authorized. Well, there's a few that are authorized to swear in someone into being a U.S. citizen, right? So if they're approved for naturalization, they can be sworn in by a federal judge or by the director of USCIS. Now, state court judges can also be allowed to do this as well, provided the court is a court of record with a seal and unlimited jurisdiction. And of course, I already mentioned the head of USCIS or USCIS officials during the administrative ceremony. They can do it too. And technically, immigration judges they're also authorized to administer the oath of office in administrative ceremonies. It's less common, though, than USCIS officers who do it because USCIS is the one who schedules and plans it, and they're not necessarily going to bring in an immigration judge to do it when they don't need to. Immigration judges have enough to do already. And like I said, there is a 120-day rule. The statute is found at 8 U.S.C. 1447B or INA 336B. The statutory clock starts ticking on the day of the initial examination. So once the interview is held, USCIS has 120 days to make a final decision, which can be granting it, denying it, or continuing it. But there has to be some sort of decision. And yeah, it's got to be a final decision, right? So there's no strict statutory deadline for scheduling the interview. That's under, the remedy for that would be under unreasonable delay under the APA probably. But once the interview happens, the 120-day clock it's a hard deadline. Okay, so if 120 days pass and USCIS has not issued a decision, sue them. It's that easy. File a federal lawsuit, and once you file the suit, USCIS loses jurisdiction over the case. The federal judge then has 2 options. They can either decide the case themselves, right? The judge can review the file, conduct a hearing, and naturalize this person directly, approving citizenship, or they can remand with instructions. The judge can send the case back to USCIS issuing in order for them to approve it, to decide it, to review it, whatever they're going to do by a specific date. Okay. And they can limit it, right? They can say it has to be within 30 days. Many times, though, a federal judge will just issue the oath of office if the person qualifies, right? Once that interview is done and they have the file, the judge then has the file, they can see there's nothing that makes them ineligible for citizenship. They can go ahead and do that. So this is different than a standard mandamus lawsuit, right? A lawsuit under 1447B effectively steals the case. It transfers jurisdiction from USCIS to the federal court. Now, fun story that we heard. It was posted online in the federal court immigration lawyers group. And let me just plug that briefly for all of you listening. If you are an immigration professional, if you are an immigration attorney, if you're an attorney and you're curious about or you practice in federal court, which is more and more common now, you're going to have to do this as an immigration attorney for sure, or as an immigration professional, at least be aware of it. Join our Facebook group, right? Answer the questions. I'll take a look and we'll see if we can improve your membership. But, the intention is this is immigration professionals who are joined there so we can share stories, get advice, sort of keep a pulse on what's happening in the federal courts with regard to immigration these days. We've got almost 2,000 members and growing. So go ahead and join us there because you get great stories and advice and things like this. So there was an individual from Afghanistan, legal permanent resident, green card holder. I believe it was Afghanistan. Pretty sure it was. And they got pulled out of line at the citizenship ceremony because it was just recently, right? The president said, hey, we're going to stop everything with Afghans now. And so they were otherwise qualified, right? They were at their swearing in ceremony. They had been approved to be citizens or to be a citizen. And then this arbitrary and capricious act of the president trying to look tough and trying to, they just go overboard sometimes, which they did this time. So this person had gone through the security screenings. They had the background check. They'd been a resident for the 3 or 5 years required. And then they're pulled out of line. Well, their attorney filed, and I'm going to look to see if I can find the attorney's name here. Well, I don't have it in front of me right now. I think it might have been Joshua Goldstein. So congratulations to him for that. But the judge essentially heard argument from the government, heard argument from the immigrant's attorney, and, basically said, the law's the law. Are you ready to be sworn in? And decided to just swear the client in at court that day. So they got their citizenship, which is an amazing victory. Okay, so again, the importance of go ahead and join our Facebook group, Federal Court Immigration Lawyers. I'll put the link in the description. Go ahead and join that and stay on top of some of the latest stories. In fact, so as I was just looking to find that out, I see that there's actually another great development happening where the U.S. District Court for the Central District of California, Judge Sunshine S. Sykes, we mentioned her previously on this podcast, issued a major decision certifying a class action lawsuit declaring unlawful policies. No, that was from November 27th. There's an updated version of that post. Let's go back here. I want to pull it up in front of me right now. Here we go. I found the post from attorney Robert Anthony Alvarez, buddy of mine. Game just changed on December 18th, the Central District of California. So that was a couple days ago. The Central District of California entered final judgment in Maldonado Bautista, certifying the nationwide class and declaring the policy of detaining EWIs entering without inspection under 1225B2 lawful. That's a great victory. That is huge. So I'm just going to keep reading this post here. This isn't an interlocutory order anymore. It's a final judgment on the merits. But we also know from the order itself that OIL, that's the government attorney agency that's going to fight, is instructing immigration judges to ignore it. Oh, this is going to be good. This is going to be great. Someone's going to go to prison for this. Somebody's going to go to prison or lose their job over this. So you have an order from a federal judge in a nationwide class action. That's the Maldonado Bautista case. And again, that's the case where attorneys filed suit, and because we can't get nationwide injunctions, they have to be filed as class actions now. The attorney said, okay, we need a nationwide class action declaring anyone detained who was, is, or will be detained if they entered without inspection, they're here for more than 2 years, and then government's trying to detain them and put them and hold them without bond, without opportunity to ask for a bond, saying they're mandatory detention, if that happens, it's unlawful, right? So that's what they sought. They got the class provisionally certified. Now there's a final judgment saying it's certified. And this is great. So I'm going to review this for just a second. I'm just going to cut audio here. We're going to jump back in because this is another thing. It wasn't on my list, but now I see it and we got to talk about it. Oh man, Robert, thanks for the update on this. Okay, so I've just finished reading the post here and there's a great new strategy to use. All right, so for immigration attorneys out there, first of all, OIL is the Office of Immigration Litigation. They're part of the Department of Justice. They're the lawyers who are telling immigration judges how to do their job. And it looks like they told the immigration judges to tell the federal judges to go F themselves or to go F off, right? We got to keep the language friendly here. It's a family show. So new strategy being proposed here by Robert Anthony Alvarez, attorney at law, licensed in the state of Michigan. All right. Don't just file the bond motion with the immigration judge. Simultaneously file a habeas petition. Cite this decision in the habeas petition. And that way, you know that the immigration judges are going to be aware that federal judge eyes are already on it. And look, a federal judge can hold someone in contempt and send them to jail, right? They can enact all sorts of grief on someone's life if they're going to ignore a federal court order. We see that starting to play out in some other cases, in the Abrego Garcia case where DHS was instructing their people to tell the courts to go F themselves and don't turn the planes around. Yes, make the planes take off and bring these people out of the country in violation of a federal court order. Okay, which you can't do. That's illegal. And so I think we're going to see some heads roll on that one. So yeah, this is a great strategy. File both at the same time. File a habeas petition and file a bond motion at the same time. According to the post here from Attorney Alvarez, don't worry about exhaustion because the order in Maldonado Bautista, itself recognizes it's futile, right? It's futile to be requesting bond when they've already been instructed to detain everyone under the name of the case that the court is trying to use is Yajur Hurtado. Okay, so they're already instructing immigration judges to ignore federal court orders. And of course, DHS has and is doing that. So we're in a bit of a constitutional crisis, you can imagine. But yeah, and then update your pending habeas cases. If you have a pending habeas corpus case, submit a notice of supplemental authority right now because there is new law. As of December 18th, there is a nationwide class that is certified, right? So it was done the right way, according to Casa v. Trump or Trump v. Casa, whatever case that was that said there's no more nationwide injunctions, but we still nationwide class actions. Okay, so let's move on to the next item of business here. Like I said, there's a lot this week, actually. There has been a ruling in a federal court in Washington in the case of Mendoza Araiza v. Wamsley. The judge ruled that the Laken Riley Act cannot be applied retroactively. So in that case, Mendoza Araiza v. Wamsley, the petitioner, well, let's give you the citation. It is 2:25-CV-2139. That's the Western District of Washington. This is an order from December 8th of 2025. Okay? So the petitioner is Uriel Mendoza Araiza, a longtime resident, this green card holder. The crime in question was a single shoplifting conviction from 2006, nearly 20 years ago. ICE arrested him in September of 2025 and held him without bond. And they justified that by arguing that under the Laken Riley Act, which was just passed this year, that any non-citizen with a theft or shoplifting charge is subject to mandatory detention, meaning they can't ask a judge for release while the case is pending. So the core issue here was really retroactivity. Now, the Laken Riley Act, even the Department of Justice lawyers had to admit, doesn't contain any language about retroactivity. Okay, so it doesn't address that topic. And if the statute doesn't say this is retroactive, then it isn't. There's a strong presumption against retroactivity in statutory construction, in interpretation of the law. So you can't just say anyone ever, forever is subject to the Laken Riley Act if the retail fraud thing happened years ago, right? If it happened before the date of enactment of the act or the effective date. Okay. Initially, ICE's position was that it applied to everyone. But again, They conceded. The Department of Justice conceded. And probably a few people will lose their jobs because of this, because it's detrimental to the whole case, right? It's just, at least for justice, it's great. For Donald Trump and his buddies, it's not great at all, because it really limits the effectiveness, limits the reach. I'm not going to say effectiveness. It limits the reach of retroactivity, because retroactivity is very unfair. So there were a lot of cases dealing with waivers in the past. There was a case called St. Cyr, and it had to do with waivers that were available for certain criminal activity if it was based on a conviction before a certain date or after a certain date, when there were changes in the law. And we've won these cases in immigration court for clients, allowing them to maintain their residency or obtain again their residency because they were able to get a waiver for some stuff. And so in the immigration context, if you're going to draft an immigration law, you got to know what you're doing. And if you want it to be retroactive, you have to be specific about it, and you have to address how it's not going to be unconstitutionally unfair to someone. Because what happens is people will, if they get in trouble for shoplifting, let's say, they'll weigh the pros and cons of fighting the case. They'll ask their attorney, they'll say, hey, should I fight this? I mean, maybe I did it, maybe I didn't. Maybe the intent was to steal, maybe it wasn't. Should I fight this or not? And the attorney could say, well, you know what? There's really no immigration consequences because it's a petty offense or petty theft offense. So it doesn't affect you if you don't do it again. And for citizenship purposes, you just wait 5 years. You'll still be able to apply for citizenship. And then the client, the immigrant, will rely on that legal advice. So they have detrimental reliance on the law as it was at the time that they either were convicted or took a plea deal. Usually it's in the context of a plea deal. That's what would make it unfair, really, is if they relied on that statement from the attorney and the way that the law was, where there's no negative consequences for just pleading guilty to this other charge or just paying the fine or whatever. So it becomes unconstitutionally unfair. It's a violation of people's due process rights if you go changing the rules 20 years later. So you have to take that into account if you're going to make a statute retroactive. And they didn't, and there's no retroactivity language in the Laken Riley Act. So the judge ruled that because the act isn't retroactive, the defendant here was illegally detained under the mandatory detention statute. And so they ordered him to get a bond here. Okay. Now, right now, this establishes that old convictions, right, pre-2025, can't trigger the new mandatory detention provisions of the Laken Riley Act. That's good, because the Laken Riley Act, as you'll recall from an earlier episode we did on that, it includes retail fraud. So theft, it could be a minor thing, like you stole a candy bar. Maybe you were 18, 17, whatever. You stole a candy bar, and now you're subject to mandatory detention because they want you to be. But it can also be if you're accused of it, or if you're even accused of resisting arrest or assaulting a police officer, which many police officers and prosecutors, that's like their modus operandi, right? That's just the way they operate. If you give them any attitude, well, now you're resisting arrest. And we see this all the time on TikTok and videos that people take. A cop gets on a power trip, and now they're accusing you of assaulting them or resisting arrest. And it's just not what happened. But because you're accused of it, after the effective date of the Laken Riley Act, you can be mandatory detention then as well, even if you weren't convicted of it. There's probably some sort of constitutional challenge available there. We'll see what happens. But it's pretty harsh when it comes to that. Now, in the operations in Chicago, and now the most recent Operation Buckeye, right, where ICE is recently just highly enforcing things. They're going after the bad guys who had a criminal conviction that may have been as minor as retail fraud, which again, retail fraud is the legal technical way of saying somebody stole something from the store. It could have been something very small. Right. And I've sat in on court hearings in criminal court where, you have someone who's like, but judge, I was in a wheelchair. I had to grab something and put it on my lap. And then I'm going through here and I literally can't feel my legs and I didn't know it was here. So you never know if someone is innocently pleading guilty to that, whether they should have defended themselves. But because of the minor nature of the offense, usually, being trespassed from the store and a small fine, a lot of people just accept it, plead to it, or plead to something else and get on with their life instead of going through a lengthy court process. So one more reason to counsel your clients that, no, if you didn't do it, we need to fight this. Now, again, as I mentioned in the introduction, if you go to the USCIS.gov website, you'll see that the first image in the slider there is Making America Safe Again. And we got the end of year review with the 2025, the year there. And it's written the same way that it was, like the logo type, the design of it is the same as it was on Project 2025, right? So this is no coincidence. But they're releasing what they call an end of year report. And it's really not a report. This is really some sort of BS document that they want the president to read so that they don't lose their job over at USCIS. And what it does is it just basically outlines all the things that they've done this year that the president told them to do and that they wanted to do, and that was in Project 2025. There's really nothing new or extraordinary here. It's essentially saying, oh, we're protecting America. Yeah, threats of public safety. Yeah, as soon as that Afghan shot the National Guardsman in D.C., we did this and we did that and we did this. This is a fluff piece, right? You don't see any real statistics here. You don't see any real numbers on like approvals or denials or how many petitions they processed, how many new petitions for this or that or the other thing. Instead, they're just going through their list of, declaring their war on fraud, right? Great, another war. Tightening up that they're, ensuring that there's no legal defense for a false claim of U.S. citizenship. There already wasn't, essentially, right? They release a 2-page memo, and it really changes nothing, because when you make a false claim to U.S. citizenship, unless you can meet a very narrow exemption, you don't get a visa anymore, right? You're permanently inadmissible to the United States. So, so in that memo, it didn't change anything about making a false claim to U.S. citizenship. There was a case, matter of Junyun Zhang from 2019, right? So this is a few years ago now, where the Board of Immigration Appeals, essentially, they were dealing with this individual who, I don't know if he was printing them himself or bought falsified certificates of citizenship and then represented himself as a U.S. citizen. They said, we don't need to show if you intended to do this or not. Like, you had it. Like, you were showing people you're a U.S. citizen. So you tried to get citizenship through a shortcut, you failed, and so now you falsely misrepresented yourself as a U.S. citizen. We don't need to show intent to establish that this person is deportable for making a false representation of U.S. citizenship. Okay, that's what that said. And again, that's from 2019. So if we got to thank anyone, we can thank the Biden administration. That's when it happened, if I'm not mistaken. 2019? Yeah, because it was... Oh, no, that may have been under the first Trump administration, right? Because 2020, January 1st, or January 6th is the whole fiasco there. Anyway, so they're just... they wrote something in the manual to incorporate that. Big deal. That's like almost nothing. Anyways, in this report, what do they talk about? They talk about how they cut the validity period for work permits. You don't automatically get renewal in certain visa categories. They're closing TPS for all these other countries, and they're so happy about that. It's really much of a nothing burger. So I would say you can go take a look at it, but really no need to waste your time on it. In other news, there is a case of an individual who, because they're from Iran, and because there is this 19-country pause, it's actually creating sort of a trap for ICE. You can't hold someone indefinitely for immigration purposes. There's no long-term jail sentence you can give in a civil immigration case. Okay, in a criminal immigration case, yeah, there's other stuff. But in the civil case, you can't do that. So if they're detaining someone and says, hey, well, you're from Iran, therefore we're going to detain you now, but then they can't remove you, they can't hold you indefinitely. So on Friday, so December 19th, a federal judge ordered the release of an Iranian national, a bodybuilder named Ziai, who had been held for nearly 5 months. Nothing to do but pump iron in the gym of the jail, I guess. And this is one of the first major cracks in the hold everyone strategy for these 19 banned nations, right? Where you can't get a visa, you can't get anything else. And also, if we can't return someone to that country, we can't just hold them indefinitely. That was part of the problem. And that's also part of the problem that Abrego Garcia is dealing with right now as well, right? He can't legally be returned to El Salvador. That's where he was seeking safety from. Was it El Salvador or Honduras? He can't be returned there, right? And they can't hold him indefinitely. So he's actually free for the moment. I don't know if when this goes on air, he'll still be free, but for now he is. And the federal judge in that case said he has to remain undetained. And there's a case coming out of Colorado by immigrant rights activist Jeanette Viz. Her lawyers argued her detention wasn't about enforcement, but First Amendment retaliation because she was outspoken against mass deportation raids. In that case, it was a federal judge in Colorado. Let's see here. The federal judge agreed enough to grant bond, signaling that courts are watching for political targeting. Right? So it's a retaliation case in that sense. So if you have a client who's outspoken, it's not a great time to be outspoken on this stuff, but if they are and they're ICE is going after them because of it, you definitely want to raise that. Okay, now we're going to switch gears a little bit because I want to talk about a visa that I think might be the next latest and greatest visa for people to start petitioning for. What have we seen? We're seeing record processing times for family petitions. Those are taking longer. We're seeing record processing times for U visas, for T visas, right? A T visa, I think when I looked last, can be up to 8 years waiting now, where U visas are up to like 40 because there's way too many people applying, not enough that can be given, and therefore there's a wait list, right? And the government is consistently dragging their feet on issuing work permits to individuals in those categories too. So, again, we have to go to federal court to make that happen. But let's talk about the H-2A visa. So H-2As are unique. A lot of visas have limits, right? 10,000 U visas per year, 5,000 T visas per year. H-2A visas have no numerical limit. So an H-2A visa is a temporary agricultural worker visa, typically designed for one season. However, you can there's ways or strategies to extend that for up to 3 years at a time. A person can be physically present in the United States on an H-2A visa for up to 3 years without leaving. And there's ways to do it where they're not violating their visa status, so they can be working that whole time. And at the end of 3 years, they just have to leave, be outside of the country for at least 60 days, and then they can get another H-2A visa, right? That clock resets. They can come in. If they get another H-2A and they plan it correctly, they could have another 3 years of agricultural work in the United States. That's going to be important. And there's some organizations that exist to help facilitate this. But I think one of the big keys here is there's no numerical limitation to the number of those visas that can be issued, right? Now, the H-2A, there's a few different things that have taken place recently, but to understand the changes, we need to understand a little bit of the background. Okay, so there's essentially two components. You need to file a petition with the Department of Labor. They need to approve it, and then you have to file a petition with USCIS, which also needs to be approved. Now, with the Department of Labor, the goal is, a couple weeks. With the department, with USCIS, the goal is that they're going to take, a couple weeks, maybe a month, in order to get these things approved as well. It used to be you had to file with the Department of Labor first. Once you got that approval, then you can file with USCIS. But due to some updates in early 2025, well, let's see, the effective date, there was a new rule that went into effect effective October 2nd, 2025, right? It was announced earlier in the year. It's effective already. For H-2A petitions that are requesting unnamed beneficiaries, you can actually file those two petitions at the same time. You can file with the Department of Labor and you file with USCIS. So essentially, Department of Labor gives you a case number or a receipt number. You include that when you file with USCIS. And then you have those two petitions. They can be pending at the same time. And USCIS is going to check regularly, probably daily or every couple days at least, with the Department of Labor to see if they've made their determination. As soon as they do, that case can go on to the consular processing phase. Okay, now there's a couple ways to do H-2A visas. You can say, oh, I know someone, they're here, they're in a different status, I want to petition for them. Or, so you're naming someone specifically. That's going to take longer. Or you can do an unnamed beneficiary or unnamed beneficiary is what it's called. And you say, I don't know who they're going to be, but I need 20 spots to fill on my blueberry farm. So I'm going to file the petition now, get permission from immigration and the Department of Labor. And then when I'm ready to send people for consular processing, I'll use a recruiter likely located in the foreign country where I'm going to bring labor in from. I'm going to use that recruiter. They're just going to find people who are willing, ready, able, healthy enough, qualified, hopefully not inadmissible to the United States due to previous immigration or criminal history violations or substance abuse problems. And so that recruiter can then, grab these 20 people. They can find 20 people, and we send them for consular processing at the U.S. consulate in that foreign country. So they go through the consular interview, they get their visa, they can enter the United States, and then they can stay for up to 3 years, right? Typically, they're going to stay for that agricultural season that they were hired for. Okay, they can't stay longer. There's a I think it's like a 30-day grace period, or maybe it's a 60-day grace period. I had it written down here. But the point is, all of a sudden, you can file those two things at once. You're going to save a lot of time. You can get people in more quickly to work on those agricultural jobs. There's no visa number limits. And as long as you can show that there's a legitimate seasonal need for them, you're good. And if they get here and say the blueberries don't ripen on time, you can file an extension. And your people have permission to keep working as long as you filed the extension. You don't even need it approved yet for them to keep working without violating their visa. So that's another neat little fact about the H-2A program. Right, so there's extensions, and also if the season ends, they have a 60-day grace period to find another H-2A employer in the U.S. And again, if they find another H-2A employer here in the U.S., that employer only has to file the application for that H-2A visa holder to already start working. So it's pretty convenient when it comes to that. Now, you got to have everybody staying on top of it. You definitely want an attorney handling this, so nobody accidentally violates the statute or the law or is not in compliance or something like that. But we're going to need a lot of agricultural workers who are here lawfully. We've seen a lot of people get removed, a lot of people get picked up, and there's instances where crops are failing and they're just rotting on the trees, or they're dropping and rotting on the ground. And it's difficult, right? It's difficult for U.S. employers to stay competitive, U.S. farmers, agricultural concerns. It's difficult for them to stay competitive if they don't have labor. Right now, as much as some things are going robotic, you still need agricultural workers for pruning, for caring for crops, plowing the field, all sorts of stuff. Okay, so I think that may be an unsung hero, because one of the strategies that are frequently used is is a bunch of farms will join a collective or a cooperative, right? So they'll form some sort of nonprofit cooperative, and then this cooperative will be the employer for purposes of the H-2A visa. And then because you may have people whose seasons are different, you could have someone riding, again, that's like an agricultural worker circuit. And if you know the farms that need the labor, and if you contract with them ahead of time, well, then this farmers cooperative can actually say, yeah, I need an H-2A visa worker to come in for this seasonal job at that farm, and then this seasonal job at this other farm, and this other seasonal job at that farm. And voila, they're employed year round. You can do that for 3 years, and then they leave for 60 days, enjoy the fruits of their labor. They can come back on another H-2A visa. Now, this visa is not new. The new thing here is a lot of farmers are losing their workers. The new thing here is the change in the regulation or the rule where all of a sudden you can file simultaneously with the Department of Labor and with USCIS. And I was looking into this a little more deeply, because I get curious about stuff like this. The foreign recruiters have to follow certain rules. Now, it's hard to regulate someone who's not in the United States, right? They're not allowed to charge people to get a place on the list. They can't charge them a recruiting fee or anything like that. There's supposed to be zero fees. And then the way that USCIS and the Department of Labor hold employers accountable is they say, well, we're going to hold you strictly liable for violations of your recruiter. So if you've got a recruiter down in Mexico who's like, hey, I got 20 H-2A visa spots, give me $1,000 and I'll put you on the list and you're going to get a visa. That's a violation. They're going to be held, the employer in the U.S. will be held responsible for that. So they got to keep their contracts tight. They got to keep a tight leash on those recruiters to avoid abuse of the system. And there's other states that have their own employer or migrant worker protections as well. So it's important to be aware of those. Things like a foreign recruiter, those have to be disclosed as well. So that becomes public information. All right, so that H-2A visa, especially the fact that you can get with those unnamed ones, I mean, all of a sudden, in a climate where we know there's a lot of Republican conservative farmers, we know that there was this rule change earlier in the year. It's effective now. It does benefit farm labor, agricultural labor. I think we might see the rise of more of these agricultural labor organizations. I mean, there's nothing that's really stopping you from organizing that, putting some data together, figuring out who needs labor in what parts, getting them to join the collective, and of course, drafting the contract so nobody ends up going bankrupt if there's a violation or something like that. But I mean, that's pretty neat. That's pretty neat. Now, this isn't a new program, so it's been subject to abuse before. So there is strict transparency requirements, strict rules. I mean, if you're bringing in an agricultural worker, you got to provide housing. That housing has to be inspected. That housing has to have a certificate of inspection saying, yes, this is a decent place to live. There's heat, there's air conditioning if it's going to be hot. There's water to drink, there's clean water, things like that. It's not infested with bed bugs or rats or raccoons or things like that. So there is a lot that goes into it. But I think, someone with the right motivation could really take this and run with it, because unlike things, let's call it like a temporary high that some immigration attorneys or immigration professionals might get from filing massive amounts of U visas or T visas, where we know there's massive abuse going on with those as well. U visas, T visas, VAWAs, highly subject to abuse, highly subject to fraud. As those get cracked down on more, you might find that there's a pool of immigrants who are outside the United States who are amenable to coming here and working hard, want to do it the right way. And I know that's a loaded phrase. That's probably going to trigger some people when I say do it the right way. But come in with a visa, right? And in compliance with a visa that allows them to work continually for 3 years if properly organized. But again, there are requirements. Housing, lodging. You can't make unlawful deductions from their salary. You must provide that housing. There was something else, travel, right? They're inbound to the U.S. travel and their outbound travel. The employer is on the hook for that. You can't extract that some other way from the employee. And of course, there's wage requirements as well. So those are all things to consider. I thought that would be an interesting topic for today, just considering the retarded level of enforcement that we're seeing. And I say retarded not in any demeaning way, but the people who are enforcing it like this are probably retarded because they're constantly violating the law. They're detaining people as if they're an arriving alien when they're clearly not. They're holding people without bond when they should be getting bond, necessitating a nationwide class action. So that's the update for today. A little bit of a shorter episode, but some of the things I thought would be worth talking about. So again, thank you for joining us, and here's a quick word from our sponsor. Now, as always, we're sponsored by Prima.Law. That's immigration case management. We are a legal case management platform specially designed with additional features for immigration attorneys, so we can really bring out the best in immigration attorneys, helping them serve their clients better by accepting online payments, using the client portal, sharing that checklist directly so your clients can share those secure documents in a very secure manner. Find a free 15-day trial at Prima.Law. That's for immigration attorneys and immigration professionals. Let's start the show.